New details tonight on the soaring costs involved in the Aurora Theater shooting trial. 7 News investigator John Frugia has been compiling the numbers for us. And John, the public may never really know the actual costs?
That's right, Ann, because the state public defender's office that represented the killer and paid expert witnesses, investigators, lawyers, and staff, well, it says it does not have to let the public know what it spent. And given that the DA and Arapahoe County Sheriff's costs for the trial and the public and all that money they spent, the public defender's bill is thought to be in the millions.
It's a matter of accountability.
Republican State Senator John Cook, a member of the Senate Judiciary Committee, says both the legislature and the public have a right to know how much the state public defender's office spent on the trial.
Public money, your money, my money, the state's money, taxpayers' money, where's that money going? And they have no accountability to the public who is funding them. And that's the problem. There's a lack of transparency and a lack of accountability.
That is not the case with other agencies like the Arapahoe County Sheriff's Department. Sheriff Dave Walcher has a detailed accounting of the cost of detention for the killer, transportation, and trial costs. It totals more than $1.6 million, with just over $400,000 paid for by federal grants. The DA's office has also made public its costs, some of which were reimbursed by federal tax money. They include more than $680,000 on victim services, more than $220,000 for expert witnesses serving subpoenas and other costs, and more than $470,000 for victim witness advocates and a DA to work with them. And that doesn't count hundreds of thousands of dollars in DA and staff salaries of those assigned to the trial. But the public defender's office says it doesn't function under the same rules.
When you're not accountable, you just say, well, trust me, we spent the money wisely. That's the problem.
In fact, the public defender is operating under a different set of rules, those set by the Supreme Court governing professional conduct. Specifically, there is a rule that states clearly a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. Cook says confidentiality could be protected while still being transparent.
People don't want their names used on that, or if the public defenders don't want the names used. I can live with that, but where's the money going?
Now, the answer is we're not likely to find out, because even if the legislature were to pass a bill requiring disclosure of costs, it's not clear how the judicial branch would respond. We reached out to the state public defender's office late last week. Our calls weren't returned.